Yes.
For admission, item 1.
Lordship, this matter, Miss Mary is handling this matter. She's on legs right now. If this matter can be passed over for some time.
Yes, so what we were required is to file the show cause reply, which is not filed yet, isn't it? So
Maybe
we'll
she has
fix
something to
another
say.
date,
Yes.
isn't it? Mr. Chung Adalon,
And my lord,
yes,
in this case, on 17 October 2024, September also, a direction was given by this court to file several times,
yes.
but till today they have not filed.
Heard Mr. Nechung Adalon, learned counsel for the petitioner, along with
And my lord, here,
Mrs. Malsawmy, yes.
respondent number 3, the chief secretary, who got pension.
Oh, you have to file an impleadment application. So file an
next-
impleadment
okay.
first, yes.
Okay.
Who submits that he may be allowed to file an impleadment application since the respondent number 1, is it? Number 3 has been transferred during the course, during the pendency of the instant contempt petition. Mrs. Malsawmy, learned additional,
Government advocate.
you're the, yes, learned GA submits that the matter is handled by Mrs. Mary L. Kiante, learned government advocate, who is on legs in the other court. In view of the above submissions, list this matter immediately after the ensuing vacations.
Item 2.
Done, my lord.
Or just make it list after the ensuing vacation. Yes.
Lordship, in this matter, we have received a letter saying that there is an outside, they're trying to have an amicable settlement outside court between the petitioner and the state government. But however, haven't received any proper instruction with regards to that. So if if this matter can be taken up in the next week, Lordship,
Who
I'll
is
take some proper
appearing
instruction.
for the,
Mr. Vanel Haka, he is on leave right now, Lordship.
he's on leg.
Yes.
So is it possible for them to come to some settlement?
Lordship, that I haven't received any instruction on that. So I'll get some concrete instruction and the matter can be listed in the next week, Lordship.
Okay. Heard Mrs. Malsawmy, learned government advocate, who submits that certain steps are taken by the state respondents where it appears that the parties are attempting to come to an amicable settlement. She has therefore prayed for a short date, okay, so that she may be able to receive proper instructions in the matter. In view of the above submissions, list in the next week.
Item 3.
May I please your lordship? My lord, I am appearing on behalf of my senior counsel, Biagnungan Hamte. Since my senior is on his leg in another court, my lord, I respectfully pray for this matter to be listed on next week, if possible, next Tuesday, my lord.
Okay. Mention is made on behalf of Lalbiak Nunga Namte, learned counsel for the petitioner, that the learned counsel is on legs in the other court and that this matter may be listed in the next week on,
Tuesday.
what's the date, Tuesday? On 3rd, 12th, is it? Is it? Tell me, what's Tuesday? 3rd, yes, on
Yes.
3/12/2024. Accordingly, as prayed for, list on 3/12/2024.
Sure, Your Lordship.
Item 4.
My lord, on the last court day, we were directed to find out the proper address of the respondent, and we have taken the fresh step regarding the direction of the court. And however, my lord, the notice has not been returned yet. So let the service report be awaited with regard to the fresh step taken by us.
Is your name here in the cause list? Are
I'm
you
sorry, my
still
lord.
Lalshatpui?
No, my lord, I'm appearing on behalf of my senior, Bila Ramenga.
Okay. Miss? Miss
Laltan Louis.
Laltan Louis, appearing on behalf of her senior, Mr. B. Laram Enga, Learned Counsel for the appellant, submits that fresh notice was issued to the respondent through their proper address on when was it issued?
19/11/2024.
19/11/2024. However, return of AD card is not received till date. In view of the above, list the matter after the ensuing vacation. Yes.
That's my lord.
Item 6.
Yes.
Lordship, this is a village council suspension matter. In the last court order, today is fixed for considering my prayer for interim relief.
Yes. So, in the last court date, Ms. Caroline Kelan Lungoy, you had submitted that you have not received any instructions in the matter.
Yes, my lord. As of today also, I have not yet received the instructions.
Okay, then, in the meantime, what is the nature of the interim prayer? Let's see your petition.
In
Where
page,
have you made the prayer for interim?
page 22, our prayer is to stay the operation of impugned suspension order dated 19/6/2024 and further extension of suspension order for another 3 months, dated 1/10/2024. Till the
So if
final.
it's 1/10/2024, it
Yes.
is the suspension order,
It is for 3 months.
11/12. First 10, 11, 12, till the next year, is it?
Yes, it will
Let's
be
take
exist-
us to the interim order, the order, implement order.
It is in page 48, Annexure 9.
Yes, what does it say?
Under the provision of Section 9(1) of the Chakma Autonomous District Council Village Councils Amendment Act 2011, the Executive Committee of Chakma Autonomous District Council is pleased to extend the suspension period of Ajasorachi Village Council for a period of 3 months with immediate effect. Further, the Executive Committee of Chakma Autonomous District Council is pleased to assign the charge of caretaker of Ajasorachi to Sri Borchoka Chakma till further order.
So now it has been suspended for how many months?
For 5 months. Initially, they were suspended on 19/6/2024, and that period was ends on 20th September, 20th 9/2024, and so the initial petition was disposed as infractious on 30th September, and on the very next day, on 1st October, the extension order was issued by the respondent CIDC.
So what are your grounds for challenging the suspension order?
My lord, there is no provision for suspension in the Chakma Autonomous District Council Village Council Act 2003. This is somewhat a covered matter, my lord.
Okay, by
In-
which judgment?
By this coordinate bench of this court. In WPC 70/2022.
Just reduce the temperature a bit, it's very hot. Yes,
In para 11. Merit.
yes.
A perusal of the above provision of law, both under the Principal Act as well as the amended Act, shows that the Village Council can only be dissolved after affording a reasonable opportunity. No power has been vested in the Executive Committee (CADC) to suspend the Village Council.
Continue.
Even under Section 14 of the amended Act, the Executive Committee (CADC) has the right to interfere in with the village administration only in the case of mismanagement of the Village Council funds or for maladministration. In the present case, the allegation made against the petitioners were inquired into, but they were not found to be genuine, and therefore, there was no occasion for the Executive Committee (CADC) to have interfered in the village administration, even assuming that the Executive Committee (CADC) could have suspended the Village Council by invoking the power under Section 14 of the amended Act 2011.
So here, it is that it is for mismanagement of the village council funds
Yes,
or
my lord.
maladministration. So in your case, what is the ground?
They used the same ground and they done inquiry, but they have not given the inquiry report to us or given any time to reply. There is no so-called notice
Okay.
upon us.
Okay, let's see the first suspension order. This is, what we read was just the extension, isn't it?
It is in Annexure 7,
Okay,
page 43.
yes, please read.
There is a typed copy on page 44. Whereas a complaint has been lodged against the executive body of Ajasorachi, headed by Sri Kalachan Chakma, on various maladministration and financial mismanagement. Whereas several maladministration and mismanagement of funds are found during the spot verification, which have been committed by the existing executive body of Ajasorachi Village Council, which is violation of 20B, 1 of the Chakmatunamba District Council Village Councils Amendment Act 2011. Now, therefore, in exercise of power conferred under Section 9, Subsection 1 of the Chakmatunamba District Council Village Councils Amendment Act 2011, the Executive Committee of the Chakmatunamba District Council is pleased to put the Executive Body of the Ajasorachi Village Council under suspension for a period of 3 months with immediate effect. Now, therefore, the Executive Committee of the Chakmatunamba District Council is pleased to appoint Sri Borchoka Chakma, son of Tabudan Chakma of Ajasorachi, as caretaker to look after the function of the Village Council President of Ajasorachi Village Council till further notification. Further, Sri Kalachan Chakma is hereby instructed to hand over the charge of the Village Council President, including all documents and seals, to Sri Borchoka Chakma, the caretaker of Ajasorachi.
So here it is maladministration and
Yes.
mismanagement.
Yes,
isn't
it is alleged.
So you're saying that copy of the verification, spot verification receipt, spot verification made was not given to you, and no
Yes,
cause
my lord.
notice, show cause notice issued to you.
My lord.
Is it?
my lord.
Now, in the village council, what's that, Chakma Autonomous Village Council Amendment Act, or the the act itself, is there provision that show cause notice should be given to you?
Since,
Anything?
my lord, since there is no suspension provision, there is a dissolution in the act.
But,
Yes, my lord, giving us
so
opportunity of being
in
heard is a
exercise
natural.
of the powers conferred under section 9(1), what is 9(1)?
Section 9(1). Section 9(1) of 2011 Amendment Act give the executive power, says
Where
that,
is it?
I have here a copy.
You should enclose everything, isn't it? You could have enclosed the Xerox copy of that provision, which is important for you, in the notification. It's not there in the writ petition itself. It should be here so that for easy reference, isn't it? Anyways, yes, okay, 9(1).
That is the principal act,
yes.
my lord. It is in section 14, page 9,
Page 9,
section 14.
yes.
In the last para, amended by section 9 of 2011. The executive committee shall have the right to interfere in village administration in case of mismanagement of village council funds or maladministration in the village council. That's only. It is a vague provision.
But you're not challenging the provision itself. So here, isn't it, if you are challenging this, it has to go to the DB. So they have the power to abolish an already created village council if it is not fulfilling that duty. So based on that, they have, so you're simply saying they do not have the power, but you will have to see, isn't it? Anyways, let's come back to the judgment referred to you, saying that it's a covered matter. Read para 11 again.
Yes. A perusal of the above provision of both under the Principal Act as well as the amended Act shows that the village council can only be dissolved after affording a reasonable opportunity. No power has been vested in the Executive Committee, CADC, to suspend the village council.
So you're saying it was not after affording, so no reasonable opportunity was afforded to you. I think
Yes,
that
yes,
can
my
be
lord.
your only ground, okay? Because if it is shown that there's mismanagement of the village council funds or maladministration, then they have the power under section.
They can interfere, but
14,
it doesn't say that they can suspend. They can be
So
suspended.
it says, if you read the Act 14, shall have the power to abolish. Abolish will be suspending.
No, my lord, there is another provision for dissolution. in section 26.
Okay, let's see.
Page 14.
So here it is not dissolved, it is placed under suspension only.
Yes.
So it's not dissolved yet. So the dissolution, the grounds for nothing is saying that it's dissolved. It is only, it is placed under suspension and the suspension has been extended, isn't it?
Yes,
So you find out what are you trying to, what is the ground for your writ petition. Now you are coming to dissolving the village council, which is not done yet. So anyways, since you're saying it's a covered matter, come to the lower part of this thing.
Shall I continue, my lord?
Yes. I'm trying to find out how is this judgment produced by you
Okay.
is to be helpful in the instant case, isn't it? Since you're saying it's a covered matter. So you can read the whole of para 11, then it'll become clear what is the previous judgment of the coordinate bench of this court. Yes.
In the present case, the allegation made against the petitioners were inquired into, but they were not found to be genuine, and therefore there was no occasion for the Executive Committee, CADC, to have interfered in the village administration, even assuming that the Executive Committee, CADC, could have suspended the Village Council by invoking the power under Section 14 of the Amendment Act 2011. Furthermore, the impugned notification dated 10/2/2022 as submitted by the petitioners was served on the petitioners only by WhatsApp text, and that too without any prior notice information, thereby violating natural justice. So also the notification dated 10/2/2022 suspending the executive body of Udal Thana 2 Village Council was only for a period of 3 months, and though that period lapsed on 10/5/2022, no further action was taken by the Executive Committee, CADC, to restore the petitioners to their position as the elected members of the Village
So
Council.
this is completely different, isn't it? The facts of the case.
My lord, what we rely is that no power has been vested in the Executive Council Committee
You have
to
to read
suspend
the
the
whole
Village Council.
paragraph. You're just reading one little part of the sentence, but when you continue reading, the reason why this was made was because, you see, the various reasons have been given. No power is given unless, okay, there is mismanagement or what? Nullified in administration. So read the whole sentence. You're just reading a part of the sentence, not even the whole sentence.
So, my lord, what we realize is that there is no provision for suspension in the act itself. There is only a provision for the resolution. They did not dissolve the village council. They only suspend. So, if they have no power to suspend, how can they suspend?
Okay, then let's come to 9. 9, what did 9 say? Anyways, shall have the power to abolish. Okay, this is concerning abolish.
Yes.
Anyways, let's hear the counsel. Government advocate, you're appearing on behalf of who passed the suspension order?
CADC.
So you're appearing on behalf of CADC, is it?
State.
No, my lord, I am appearing on behalf of the DCMA Secretary, District Council and Minority Affairs Department.
Okay,
The CADC is not being represented.
so
today.
CADC not represented till date?
Yes, my lord.
Yes, my lord.
Notice complete?
Yes, my lord.
Let's see.
We served it through Dusty and we submitted affidavit for it.
Through Dusty mode. But don't they have some council, CADC?
No, they don't have standing
Some
council
standing
here.
council?
No.
Yes, so government advocate, what do you have to say?
My lord, if in the subsection 9, section 9 of subsection 1, it's clearly written
It's
that.
to abolish, not
Yes, my
suspend.
lord. But it can be interpreted in the same language, my lord. And my lord, they also have not challenged the act.
Why should they challenge the act? The act is in their favor. The act does not say anything about suspension, so it's in their favor. You see, you simply taking your time. And when notice has been duly served to them and they have not taken any steps, I don't know.
If I'm not mistaken, the CADC have a council, but I have to find out.
My lord, we have inquired about that. They don't have a standing council. They appoint some council on case to case basis.
Okay. We'll suspend this thing. Meanwhile, we'll wait for the, we will pass an interim order. Okay. And in the meantime, since the council, the government advocate has paid for time to file their counter affidavit, we'll give them time. You heard, Mr.
Lal Sanki Maralte.
Lal Sanke Maralte, learned counsel for the petitioner, along with Miss Caroline K. Lalungoipui, learned government advocate for state respondents number,
Respondent number 2, my lord.
for the state respondent number 2. It is seen that the other respondents,
Respondent number 1, my lord.
okay, state respondent number 1. Let me see for you, because I have a feeling that you're not very sure. No. Wait. Yes, it is respondent number 1. For state respondent number 1. None appeared for respondents number 2 to 6. Though it was observed by this court's order dated just a sec. Dated 18/11/2024, that notice was duly served to the respondents number 2 to dash through dusty mode. The learned government advocate has paid for further time to file their counter affidavit. Since she has not received proper instructions in the matter. In view of the above, this court find it fit to hear the parties with regards to the prayer for issuance of an interim order staying the operation of the impugned orders dated
19/6/2024.
wait, where are the dates mentioned? Yes, 19/6/2024, and
110.
the orders dated 01/10/2024. The learned counsel for the petitioner submits that the impugned orders were issued without issuing any show cause notice to the petitioners, and further, there is no provision for issuance of a suspension order as per the Chakma Autonomous District Council within brackets Village Councils close bracket Act, 2003 as amended from time to time. Full stop. He further submits that the matter in fact is a covered matter wherein a coordinate bench of this court in WPC 70/2022 wide the judgment and order dated 21/07/2022 had held that there is no provision for issuance of a suspension order by the concerned respondents. Full stop. Ms. Caroline K. Newpara, learned government advocate for state respondent number 1, submits that even though the word suspension is not mentioned in section 9,
Yes, my lord. Section 9, subsection 1.
subsection 1 of the act, mentioned act, the word abolish is used, and it can also mean that the respondents have the power to suspend the village council. Having heard the submissions made by the learned councils for both the parties, this court find it fit to issue an interim order staying the operation of the impugned so and so, okay, dated so and so. On finding that it appears that no show cause notice was issued to the petitioners at the time of issuance of the impugned order, and therefore the balance of convenience appeared to tilt on their side at this stage. Accordingly, the prayer for interim order is allowed. This the matter immediately after the ensuing vacation for the state respondent to file their counter affidavit. Yes.
Your privilege.
For orders.
Counter affidavit and the respondents number 2 to 7, is it?
6.
2 to 6 to be duly represented. Yes.
Item 7.
Yes.
My lord, in this matter, steps were taken for service of notice to the respondents, but none has appeared till date, my lord.
Who are the respondents?
The CBI.
So CBI, please find out, because sometimes it was, I think, Ms. Zairam Sangpui, and in another case, someone else had appeared representing the CBI.
There is an appeal pending, my lord, criminal appeal 34 of 24, when the co-accused had preferred an appeal in this same matter, and there, my lord, I think this council, Ms. Zairam Sangpui is appearing in that case.
Yes, then in one case, someone else was appearing,
My lord.
representing the CBI. I don't remember which council, but it's not only Zairam Sangpui. Anyway, Mr. Lalrokunga Pautu, learned counsel for the appellant is present. However, none appeared for the respondents. This court find it fit to adjourn the matter until the ensuing adjourn the matter and to be listed after the ensuing vacation for the respondents to be duly represented. Registry, I fix the date. Yes.
Obliged.
Item 8.
Yes.
My lord, in this matter, we have served thusly to the private respondents, the respondents, 1 and 2, and affidavit in that regard has been filed on 2024.
To the sole respondent or respondents?
To the respondents, my lord.
Respondent number
Two-
1,
1 and 2,
1 and 2, is it?
yes. But my lord, since the respondent number 1 has expired, he is represented by respondent number 2, his son.
Okay. Right, Mr. Lalropu Mapautu, learned counsel for the applicant, who submits that notice was duly served to the respondents through dusty mode, and an affidavit to that effect has been duly filed. Court on perusal of the said affidavit finds that notice has been served to the respondents. However, none appeared for the respondents. In view of the above, how many days condonation have you taken?
87, my lord, 87
In view
days.
of the above, this is matter after the ensuing vacation for the respondents to be duly represented.
Obliged.
Item 9.
Yes, Your Lordship, unserved notices have been returned in respect of both parties.
Yes. And what does it say? Why is it not served?
Not found, it is.
Okay,
I don't
then
know.
you find the correct address?
Yes,
You see, because the respondent is, address is given just as Mission Wing. No
Yes.
house number, nothing. It's a huge area, Mission Wing, isn't it?
Yes.
So find the correct address. I heard Mr. Lalpian Fela Tongtu, learned counsel for the applicant, who submits that an unserved notice to the sole respondent is returned to the respondents, okay, is returned with a note that the respondent is not found in the given address. He therefore prayed that he may be allowed to verify the correct address of the respondent and accordingly issue notice to the respondent in the corrected address. In view of the above submissions, list the matter after the ensuing vacation for the learned counsel to take necessary steps. List after the ensuing vacation. Yes.
Yes. Obliged, my lord.
Hearing matters, Part 2, Item 3.
None appeared for the parties on call. Yes, wait, item number 3, it is a state appeal. So additional PP is there? At least you represent the state, since Miss Caroline K. Lalungoipui, learned additional PP is present, while
I am not the PP.
additional PP are not?
No, my lord.
Oh,